Good afternoon, everyone, and welcome. Welcome to another live edition of an employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner at Samfiru Tumarkin, LLP. Once again, welcome to another live Q&A. As our longtime listeners will know by now, we do one of these pretty much every day of the week. It's an opportunity for those of you tuning in to ask your questions. Ask your questions about anything certainly that is employment law related. So if you're dealing with a situation at work, if you're having difficulties with your employer, maybe you feel you're being mistreated by your boss, or perhaps you're even being mistreated by a colleague. Really any situation that you're dealing with at work. And certainly if you've been let go from your job, or if you've had some sort of major changes to the terms of your employment, that is a legal issue. That is an employment law issue. You should be seeking out help. You should be seeking out guidance from an employment lawyer. And this is an excellent opportunity to do so. Again, I'm an employment lawyer. I've been doing this for quite some time, practicing employment law. And so go ahead and ask your questions right now if you're tuning in. Do not be shy. Do not be bashful. There are no bad questions when it comes to employment law. We oftentimes say that the more knowledge, the more information that you have as an employee in the workplace, the more protected you are going to be to deal with any matters that come up with the workplace. And that is certainly with respect to severance. There are a lot of misconceptions about the way severance works when it comes to ending your employment. And so go ahead and ask your questions on that particular subject, but really anything under the employment law. So, and again, if you're dealing with changes at work, if you feel like you're being mistreated at work, the law can't help you if you don't know what the law is and you don't know what your options and what your rights are. And so again, please go ahead and ask your questions. As I usually start the show, and of course, if you are perhaps too shy to ask your questions online, and there's certainly no need to be, but if you want to go ahead and ask a question privately, I'll share our contact information. I'll start with our email address. And again, feel free to email us, contact us directly. The email address is help@employmentlawyer.ca. You see it on the screen right now. Go ahead and send us a brief description of the situation that you're dealing with. Tell us what your general situation is, what question you have, and I promise someone will get back to you. Go ahead and email us at help@employmentlawyer.ca. That's a great way to get a hold of us. You can also visit us at our website. We had the address on our screen a moment ago. We could share it right now again, employmentlawyer.ca. If you're looking for a starting point, if you want to know, if you have a general question about your employment law rights and you want to get a sense of what those rights or what your options might be, go ahead and visit our website. We've got a ton of resources online, articles, blog posts, lots of video clips. Go ahead and visit our website and certainly have a look through the information that's there, even from an employer's point of view. Go ahead and get a sense of what your rights and entitlements might be and your options might be from an employer's point of view. That's absolutely fine as well. If you're an employer, if you're a management employee dealing with a situation at work, our website is certainly a great way to reach out. But other than contacting us offline, whether that's by email or on our website, and of course we have all of the rest of our contact information on our website. If you want to reach an individual lawyer, for example, all our lawyers across Canada have our contact information there. Go ahead and visit the website. But for the here and now, we're dealing with employment law questions live, on stream, on air. I already see a number of questions coming in, which is great. Paul, Kimberly on Facebook, JR. That's absolutely great. As again, our longtime viewers will know, I like to line up a couple of questions to get going here. And so again, for those of you tuning in, even if you're not dealing with the situation personally and you're just curious about something, again, go ahead and type up your question. It could be completely general. It could be about severance. Give us your age, position, and years of service. I'll be able to give you a sense of what your severance entitlements may be. You don't have to mention your employer. You don't have to mention any specific details about your personal circumstances. Go ahead and ask a general question, and I promise I will get to it over the course of this show. As those questions are coming in, I did want to touch on a matter this week. It's an opportunity to talk about matters that are relevant, that are in the moment, so to speak. Spoke to a gentleman actually just this morning that I wanted to share with our viewers, and it's a situation that unfortunately we are seeing happen more and more often, and that is an employer making a change to an employee's compensation package. And so again, I spoke to this gentleman earlier today. I mean, not very long ago at all, and he had been with his employer for a good number of years in a pretty senior position, and the company was struggling financially. The company was dealing with some difficult circumstances financially, and so they approached this employee, they approached this individual, and said, you know, because of these tough times, we're going to need you to take a pay cut. We're going to ask you to take a 25% cut to your compensation. This gentleman was earning a good salary, but nonetheless, 25% of his pay was a pretty darn big chunk of change. I mean, it was very easily tens of thousands of dollars. And this gentleman obviously was shocked. I mean, he, like everyone else, has bills to pay, relies on his salary every second week to pay those bills, to pay his mortgage, etc. And so he kind of froze in the moment. He had no idea what to tell his employer, what to do. He felt kind of like he had no choice but to accept the change like this because the company was in a difficult financial position. And luckily, he is a listener of our radio show. He's a listener of the employment law show in Toronto, and of course, we do the show across Canada. And he had the instinct of reaching out to us, and so he reached out. He spoke to someone in our intake team, and he was put in touch with me, and we had a chat this morning. And I told him what I will tell everybody in a situation where they're being faced with a pay cut. An employer, this is very, very clear law, an employer does not have the right to make a significant change to the terms of your employment. And what is not more significant to an employee than their actual pay? Any kind of significant reduction in an employee's compensation package is going to trigger some rights, some protections on the part of that employee. An employer cannot force such a change on an employee. They cannot force an employee to accept a pay cut. That is what's called a constructive dismissal. Constructive dismissal is effectively a breach of contract. So by forcing this employee to take a pay cut, they are effectively breaching the terms of this employee's employment. They are breaching the contract, even if it's not necessarily a written contract. They're breaching the contract of employment between the employee and the employer. And again, that's called a constructive dismissal in the world of employment law. A constructive dismissal gives the employee the right to do a couple of things. And this is what I told this individual just this morning. Number one, you don't have to accept a pay cut like that. Don't feel compelled. Don't feel forced to accept a pay cut just because your employer is making you feel bad that the company is doing bad financially, so they have to, tighten the purse strings. You don't have to accept a pay cut from an employer. You can very respectfully and very professionally, of course, tell the employer, no, I don't agree to the pay cut. I'd like to continue on working at the same rate of pay that I've currently been working on. Feel confident, feel comfortable as an employee standing up to your employer in that way. There is nothing wrong with that. There is absolutely nothing wrong with that. In fact, it's encouraged. You are standing up for your own employment rights in a situation like that. And why shouldn't you? The second thing I told him was, if your employer does impose the change regardless, so let's say they suggest the change to you, you say, no, I'm not comfortable accepting this, and they force the pay cut on you anyway, well, now you have the right effectively to resign your employment. So you can basically quit your employment at that point in time, but treat it as a termination and get your severance entitlements anyway. So it's what we call a constructive dismissal. You can effectively resign and still obtain severance. Your severance entitlements are going to be significant. They're going to be based on your age, position, and years of service. And most importantly, they're going to be based on your full compensation package, not the reduced compensation package, right? So, and let's compare that scenario. If you accept the pay reduction and then a week later or 2 weeks later, you are terminated anyway, which sometimes will happen, guess what? Your severance is going to be based on your current reduced salary, not the previous full salary. So in a situation like that, where you're refusing to accept the change to the terms of your employment, if you're going to be claiming constructive dismissal and claiming termination, you want to do it in a way where you can claim your full compensation package in order to calculate your severance entitlements, not the reduced salary that you've rejected. So it's a lesson for all our viewers and our listeners out there. And it doesn't even necessarily apply just to a pay reduction. Any kind of significantly negative change to the terms of your employment, you have a right as an employee to refuse that change. You do not have to accept a significant change to the terms of your employment. That can be in the form, of course, of a pay cut, because again, what's more crucial than an employee's pay? It can also, however, be with respect to, for example, your schedule. If you've worked 9 to 5 or day shifts for your entire employment history, and all of a sudden your employer is now asking you to work nights, that's going to be a significant change. It can also be a question of changes to your job responsibilities. If you're a manager or a supervisor at work, and all of a sudden you are being asked to work in some sort of labor or machine operator position that's significantly different, might even be viewed as a demotion, perhaps, that's a significant change. You have rights as an employee in those circumstances. You have the ability to say no to your employer, and hopefully they back down. And if they don't back down, if they try and enforce that change, well, then you have the right to claim severance. Now, one last point on this issue, everyone, and I want to be clear for those of you out there who feel like you might be in this situation of a constructive dismissal. Before you go to your employer and resign your employment, before you claim constructive dismissal to your employer, before you get into any of this with your employer, it's extremely important that you get legal advice first. These situations sometimes are very nuanced. You want to make sure that you're saying the right thing, doing the right thing at the right time. You want to act strategically here. You don't want to act without legal advice first. And so if you feel like you're in a constructive dismissal situation, as this gentleman was and as this gentleman did, make sure you reach out to us, give us a call, send us an email, however you want to get a hold of us. Post the question right now if this is ringing a bell. Make sure you speak with a lawyer first. Do not go to your employer and quit thinking you're going to get severance, because again, you may be taking a misstep there. You want to make sure you speak with an employment lawyer and that you understand fully what your rights are, what your options are, and what the best option is when it comes to your particular situation. All right, I think that's enough, guys. Hopefully that helps a few of you out there dealing with changes to your employment. It's time, drumroll please, for the questions. Thanks again to those of you that asked that asked your questions. I see a couple here, in addition to those I'd already mentioned, but we always line these up by order of having asked. And so Paul is first in line today. Paul, thanks very much for your question. He asks, I was hired away from a company to work for a similar company. The new company is having difficulty, and I may be let go. Would the new company be responsible for severance from both companies? Paul, excellent question. Paul on YouTube asked this question. Thanks so much, Paul. And he makes a great point. The law, in a nutshell, is this, Paul. And if you've done any research yourself, you may have seen as much. But the way the law works is if you have been recruited away from secure employment, and so specifically, that requires active recruitment, Paul. So when you say, I was hired away from a company, ideally, you want to be in a situation, if you're going to claim those previous years of service with the previous employer, you want to be in a situation where you can prove that it was the company, your current employer, that recruited you away from your previous position, that they reached out to you, for example, that they enticed you to join this new employer. Perhaps they offered you a raise or a signing bonus. They convinced you to leave your secure employment and join this new entity. That is point number one, Paul. You need to be able to prove that. So ideally, there might be emails or text message exchanges or some sort of evidence of, again, your current employer having recruited you away from your previous employment and enticed you away from your previous employment. That's step number one. If you could prove that, Paul, you're halfway towards including those previous years of service as part of your severance entitlements. Now, the second piece of the puzzle, Paul, is, and it sounds like it may very well be the case here, although you haven't been let go yet, If you join that new company and then not long after your hire, and I would say within the first year or year and a half or so, perhaps even 2 years, if within a relatively short period of time you are subsequently let go from that new employer, then you may very well be able to claim those previous years of service with the previous employer as part of your severance entitlements. Right? So in other words, you have to be let go relatively early on within your employment with your new employer. If, Paul, you are a 3 or 4 or 5 or 6 year employee plus, then I would say it likely becomes impossible to include those previous years of service. In other words, you have to be a short-term employee with that new employer in order to make that claim of including those previous years of service. Last piece of information, Paul, that will be relevant to your matter. And if you are let go, Paul, by all means, you need to reach out to us immediately. Do not sign anything, of course, on the spot when being offered a severance package, and make sure you speak with one of our lawyers as soon as possible. One other thing we'd likely ask for in assessing your severance entitlements and making sure that you receive a reasonable severance offer in the circumstances is your employment contract. We want to have a look at your employment contract, see if there's any termination language in there that potentially limits your severance entitlements or not. Do keep in mind as well that if there is termination language in your employment contract, there is a very distinct possibility that it is unenforceable. And so even if you have a look at your employment contract and you see that there's a paragraph about termination there, or there's a paragraph about severance there, for any employee, do not assume that that language in your employment contract limits your severance entitlements. Termination provisions in employment contracts need to be very carefully worded, very carefully drafted. Even the use of one wrong word or one wrong phrase, or certainly a wrong sentence, can render the entire termination paragraph completely unenforceable. And so again, don't just assume that your employment contract limits your severance entitlements somehow. Don't take your employer's word for it. If you're let go, Paul, and you're faced with a severance offer and you're dealing with a situation certainly where you were recruited away from secure employment and then let go not long after, you need employment law advice quite desperately in a situation like that. Listen, hopefully it doesn't come to pass, but if it does, you know where to find us. And thanks very much for the question, Paul. All right, next in line is Kimberly on Facebook. Kimberly asks, can I be forced to work overtime? My manager says it's part of my job description, but I checked my contract and can't find that terminology. What are my rights here? Excellent question, Kimberly. And I believe you pretty much answered it in your question. So good for you for having that instinct to check your contract and check your job description if you have one. If it's not written into your contract, Kimberly, then no, there's no obligation necessarily to work overtime. Certainly, if your employment contract says you work 9 to 5 or some sort of regular schedule, well then, of course, that is a term of employment that you have to follow. But otherwise, you cannot be forced to work overtime necessarily. I guess the one caveat I'll insert there as well, Kimberly, for what it's worth, is if there's a history here, Kimberly, of you working overtime hours, and you've said yes in the past, and you've kind of played ball in the past, well, then perhaps there's kind of an implicit precedence there that you might be willing and able to work overtime. I'd also be curious to know what the reason for you refusing to work the overtime hours is, and here's why I ask. If perhaps you're refusing, Kimberly, or anyone else out there for that matter, if you're refusing perhaps because you have family responsibilities outside of work, maybe you have children to care for, maybe you have an elderly parent to care for, whatever the case may be, you have family responsibilities. That is a situation where perhaps human rights protections are triggered, where an employer cannot punish you, cannot treat you differently because you have family obligations outside of work. That is protection from human rights legislation on the basis of family status. And so, for example, in a situation like that, Kimberly, and I'm speculating here, but again, I think it's important and useful information for anyone out there that is refusing extra work or refusing overtime hours, again, because they have to go home to care for their children, for example. If your employer terminates you in response to that or punishes you in response to that, that's potentially discrimination on the basis of the Human Rights Code in Ontario and on the basis of family status specifically. So, Kimberly, I would respectfully and very nicely say no to your employer, that you can't work the overtime hours, regardless of what the reason is. They can't force you to do it. And if it's the case that your employer does punish you, they reprimand you, or even, and hopefully not, but worst comes to worst, they terminate your employment for that reason. Listen, let's have a chat off air. Let's figure out what your rights are in the circumstances, what your entitlements are in the circumstances. I would not bow to your employer's pressure, even if they say it's part of your job description, which clearly it isn't, because good for you. You checked your contract and it wasn't there. All right, JR on YouTube is up next, and he asks, what is the best way to handle the worst case scenario of running out of EI funds despite constantly looking for work and communicating back and forth with employers? That is a tough situation, JR. I hate to hear it, but unfortunately, there aren't many options there, JR. If your employment insurance has run out and you are not employed, there are some social security mechanisms, at least in Ontario, to provide you with some degree of funding. I believe it's called Ontario Works. And so you can access some social assistance. And I'm talking again specifically in Ontario, Canada. But your best bet, of course, is to find a job. So hopefully something comes through very quickly. I can also tell you from experience speaking with lots of people that oftentimes Service Canada in Canada will authorize some sort of job training. So, for example, I know that there are certain kinds of job training for trucking or for certain other kinds of industries where that training will effectively be paid for you, which is a pretty significant advantage here. You can do some sort of specialized training and then go out there and find the job in that field. If you haven't investigated that, JR, it might be something worth looking into. Even though your EI has run out, there may be different programs that you can access through Service Canada, through EI, in terms of job training, and hopefully that allows you to find your job as quickly as possible. All right, JBK, again on YouTube, asks, I was denied employment insurance for not being vaccinated. Did things change yet for that? Interesting question, JBK. So this goes back to an issue that we've been dealing with over the course of the past year, and a very difficult one at that, in terms of employers, lots of employers rolling out vaccination policies, requiring employees to be vaccinated, and lots of employees being either put on unpaid leave or in fact being terminated from their employment as a result of those vaccination policies, and as a result of either not being willing to disclose their vaccination status or alternatively of confirming that they haven't been vaccinated. JBK, what I can tell you is this: the decisions are always made on a case-by-case basis. I can tell you that I've had a number of matters where the employee was let go because they were not vaccinated, where those employees did end up getting employment insurance. So it is certainly possible, JBK, to get employment insurance despite the fact that you were let go or put on unpaid leave because of a vaccination policy. Now, obviously, that's not every case, right? Some people have still been denied EI for that reason. If you haven't recently, I would reapply at this point in time. It could very well be, and there's nothing confirmed on this issue, but it could very well be that very quietly, internally, Service Canada has changed their approach to these kinds of situations. And it's possible that you may qualify for EI, or at the very least, you might be able to appeal that decision. I would give it another go if you can. I can also tell you, quite interestingly, that lots of employers have reversed these vaccination policies. An example of this very recently was the TTC in Toronto, the Toronto Transit Commission, who, if I remember correctly, just a week or two ago, effectively kind of ended their vaccination policy and are now asking employees to return back to work even though they were unvaccinated, even though they were let go from their jobs, they're being recalled back to work. That's just one example of lots of employers changing their approach to this vaccination issue. And so, JBK, that might give you another opportunity, perhaps to either seek employment where previously it wasn't available, or again, perhaps give EI another chance. But I can tell you, kind of on the record, so to speak, nothing has changed in that respect. Appreciate the question. All right, perhaps last but not least for today, BC Pinoy on Facebook asks, my wife was diagnosed with mental illness. She was approved for short-term disability that lasted 6 months. However, she was refused to proceed with LTD because she believes that there was nothing wrong with her. Now she's unemployed, not cooperative, and the company doesn't want to entertain my inquiries about my wife's possible claim. BC Pinoy, excellent question and appropriate question, only because we do oftentimes, in the context of employment and in the context of our work, talk about disability insurance, whether that's short-term or long-term disability insurance. And as a firm, we handle those matters quite a bit as well. And so asking a question about disability insurance is certainly appropriate. I will try and be kind of brief and to the point here, BC Pinoy, only because I want to make this as kind of easy to understand as possible. The analysis is this effectively. If your wife remains medically unable to work, if she's continuing to receive treatment from her doctors and her doctors confirm that despite the fact that she's not on LTD, she is medically unable to work, the insurance company was wrong in denying her claim. You have a legal claim as a result against the insurance company in a case like that. So, again, if the medical records demonstrate that she was unable to work, regardless of what the insurance company said, regardless of the fact that they denied her claim, they should have in fact approved it. And so you should be pursuing the insurance company in that respect. And what I would suggest, BC, is give us a call. Let's have a chat about that. Again, we handle these disability insurance matters, and we have gone up against every single insurance company across Canada, and we have a proven track record at resolving these claims successfully. And that's on the disability insurance side of things. BC, again, you want to move as quickly as possible in that respect, and it sounds like you may very well have a claim. Again, that's assuming that your wife remains medically unable to work and has that confirmation from a doctor. Now, on the employment side of things, BC, if her employer, if she's unemployed now, she may also be owed some amount of severance from her employer. Now, this depends, BC, in which province you reside in. But certainly I could tell you in Ontario, if an employee is no longer employed with a company because they were medically unable to continue her employment, they're still owed a certain amount of severance anyway. The employer doesn't just get to, throw an employee by the roadside and say, oh, well, if you can't work, you're no longer employed and we're done with you. That's not how it works. Those employees are still owed severance. And perhaps more interestingly, if the employer let that employee go too quickly, they may even be owed additional compensation for the way in which the employee was treated. An employer has an obligation to accommodate an employee who's on a medical leave and to not terminate their employment if there's a chance that that employee might be able to return back to work. And so again, BC, if your employer let your wife go too quickly because they thought that perhaps she was permanently disabled, you might be entitled to not only severance, but additional compensation as well. BC, it sounds like you've got a couple of legal issues here, one from a severance point of view, perhaps another from a disability insurance point of view. I very much suggest that you reach out to us off air. Again, send us an email, give us a call, visit our email or our website, however you want to get a hold of us, contact us. Let's have a chat about your matter confidentially. Let's figure out what your rights are, what your wife's rights are, that is, what options she has, and take it from there. And that's a great way to end today's show, everyone. Thank you so much for tuning in. Hopefully, at the very least, I provided some of you with some insight and pointed you in the right direction and provided some general information and advice as well. I believe we have another show coming up tomorrow with my good colleague, Jeremy. Stay tuned for him and make sure to ask him lots of questions as well. Until then, everyone, have yourselves a good rest of the day and take care. Until next time.